a dissenting opinion in our last case. Christian Legal Society, chapter of the University of California, Hastings College of Law versus Martinez. Justice Kennedy, concurring. An objection might be that the all-comers policy, even if not so designed or intended, in fact makes it difficult for certain groups to express their views in a manner essential to their message. A group that can limit membership to those who agree in full with its aims and purposes may be more effective in delivering its message or furthering its expressive objectives than the court has recognized that this interest can be protected against governmental interference or regulation by allowing like-minded students to form groups around shared identities. A school creates room for self-expression and personal development. In the instant case, however, if a membership qualification were formed, it would contradict the legitimate purpose for having the limited forum in the first place. Many educational institutions, including respondents, Hastings College of Law, have recognized that the process of learning occurs both formally in a classroom setting and informally outside of it. Students may be shaped as profoundly by their peers as by their teachers. Extracurricular activities, such as those in the Hastings Registered Student Organization program, facilitate interactions between students, enabling them to explore new points of view, to develop interests and talents, and to nurture a growing sense of self. The Hastings is designed to allow all students to interact with their colleagues across a broad, seemingly limited range of ideas, views, and activities. In addition to a circumstance already noted in which it could be demonstrated that a school has adopted or enforced its policy with the intent or purpose of discriminating or disadvantaging a group on account of its views, petitioner would have a substantial limited forum Petitioner would have a substantial case on the merits if it were shown that the all-comers policy was either designed or used to infiltrate the group or challenge its leadership in order to stifle its views, but that has not been shown to be so likely or self-evident as a matter of group dynamics in this setting that the court can declare the school policy void without more facts. And if there were a showing that in a particular case the purpose or effect of the policy was to stifle speech or make it ineffective, that too would present a case different from the one before us. Justice Alito, and whom the Chief Justice, Justice Scalia, and Justice Thomas join. The proudest boast of our free speech jurisprudence is that we protect the freedom to express the thought that we hate. Today's decision rests on a very different principle: no freedom for expression that offends prevailing standards of political correctness in our country's institutions of higher learning. The Hastings College of Law, a state institution, permits student organizations to register with the law school and severely burdens speech by unregistered groups. Hastings currently has more than 60 registered groups, and in all its history has denied registration to exactly one. The Christian Legal Society Christian Legal Society claims that Hastings refused to register the group because the law school administration disapproves of the group's viewpoint and thus violated the group's free right speech. The court's treatment of this case is deeply disappointing. The court does not address the constitutionality of the very different policy that Hastings invoked when it denied CLS's application for registration. Nor does the court address the constitutionality of the policy that Hastings now purports to follow. And the court ignores strong evidence that the accept all comers policy is not viewpoint neutral because it was announced as a pretext to justify viewpoint discrimination. Brushing aside inconvenient precedent, the court arms public educational institutions with a handy weapon for suppressing the speech of unpopular groups to which, as Hastings candidly puts it, these institutions do not wish to lend their names. The court provides a misleading portrayal of this case. I begin by correcting the picture. The court bases all of its analysis on the proposition. Especially if it's going to get over that. The court bases all of its analysis on the proposition that the relevant Hastings policy is the so-called accept all comers policy. This frees the court from the difficult task of defining the constitutionality of either the policy that Hastings actually and repeatedly invoked when it denied registration, for example, the school's written non-discrimination policy, or the policy that Hastings belatedly unveiled when it filed its brief in this court. Overwhelming evidence, however, shows that Hastings denied CLS application pursuant to the non-discrimination policy, and that the accept all comers policy was nowhere to be found until it was mentioned by a former dean in a deposition taken well after the cases began. During 2004-2005 school year, Hastings and more than 60 registered groups, including political groups, for example, Hastings Democratic Caucus and the Hastings Republicans, religious groups, example, the Hastings Jewish Law Students Association and the Hastings Association of Muslim Law Students, groups that promote social causes, for example, pro-choice and pro-life groups, groups organized around racial or ethnic identity, for example, the Black Law Students Association and Korean American Law Society, the La Raza Law Student Association, and the Middle Eastern Law Students Association, and groups that focus on gender or sexuality, for example, the Carla Foltz Feminist Association and Students Raising Consciousness at Hastings. Not surprisingly, many of these registered groups were and are dedicated to expressing a message. For example, Silence Right, a pro-life group, taught that all human life from the moment of conception until natural death is sacred and has inherent dignity, while Law Students for Choice aim to defend and expand reproductive rights. Hastings claims that this accept all comers policy has existed since 1990, but points to no evidence that the policy was ever put in writing or brought to the attention of members of the law school community prior to Dean's deposition. Indeed, Hastings has adduced no evidence of the policy's existence before that date. The record is replete with evidence that, at least until Dean Cain unveiled the accept all comers policy in June 2005, Hastings routinely registered student groups with bylaws limiting memberships and leadership positions to those who agreed with the group's viewpoints. For example, the bylaws of the Hastings Democratic Caucus provided that any time student at Hastings may become a member of HDC so long as they do not exhibit a consistent disregard and lack of disrespect for the objective of the organization as stated in Article 3, Section 1, the Constitution of the Association of Trial Lawyers of America at Hastings provided that every member must adhere to the objectives of the student chapter as well as the mission of ALTA. A student could become a member of the Vietnamese American Law Society so long as the student did not exhibit a consistent regard and lack of respect for the objective of the organization, which centers on a celebration of Vietnamese culture. Silenced right among limited voting membership to students who are committed to the group's mission of spreading the pro-life message. La Raza limited voting membership to students of Raza background. Since Hastings requires any student group applying for registration to submit a copy of its bylaws, Hastings cannot claim that it was unaware of such provisions. Like the majority of this court, the Ninth Circuit relied on the following joint stipulation. I agree that the parties must be held to their joint stipulation, but the terms of the stipulation should be respected. What was admitted in the joint stipulation filed in December 2005 is that Hastings had an accept all comers policy. CLS did not stipulate that its application had been denied more than a year earlier pursuant to such a policy. On the contrary, the joint stipulation notes that the reason repeatedly given by Hastings at that time was that the CLS bylaws did not comply with the non-discrimination policy. Indeed, the parties did not even stipulate that the accept all comers policy existed in the fall of 2004. In addition, Hastings itself is now attempting to walk away from this stipulation by disclosing that its real policy is an accept some comers policy. The courts also distorts the record with respect to the effect on CLS of Hastings' decisions to deny registration. The court quotes a letter written by Hastings' general counsel in which he stated that Hastings would be pleased to provide CLS the use of Hastings facilities for its meetings and activities. Later in its opinion, the court reiterates that Hastings offered CLS access to school facilities to conduct meetings, but the majority does not mention that this offer was subject to important qualifications. As Hastings' attorney put it in the district court, Hastings told CLS Hastings allows community groups to some degree to use facilities sometimes on a pay basis. I understand if they're available after priority is given to registered organizations, we offered that. Other statements in the majority opinion make it seem as if the denial of registration did not hurt CLS at all. The court notes that CLS was able to hold Bible study meetings and other events, and although CLS could not take advantage of RSO-specific methods of communication, the court states the advent of electronic media and social networking sites reduces the importance of those channels. At the beginning of 2005 school year, the Hastings CLS group had 7 members, so there can be no suggestion that the group flourished. And since one of the CLS's principal claims is that it was subjected to discrimination based on its viewpoint, the majority's emphasis on CLS ability to ensure that discrimination by using private facilities and means of communication is quite amazing. This court does not customarily brush aside a claim of unlawful discrimination with the observation that the effects of the discrimination were really not so bad. We have never before taken the view that a little viewpoint discrimination is unacceptable, nor have we taken this approach in other discrimination cases. I've never actually heard the word little viewpoint discrimination, so I'm not sure. We have never before taken the view that a little viewpoint discrimination is acceptable. Okay, yeah, correct. Nor have we taken this approach in other discrimination cases. In this case, the forum consisted of the RSO program. Once a public university opens a limited forum, it must respect the lawful boundaries it has itself set. The university may not exclude speech where its distinction is not reasonable in light of the purpose served by the forum. And the university must maintain strict viewpoint neutrality. This requirement of viewpoint neutrality extends to the expression of religious viewpoints. In an unbroken line of decisions analyzing private religious speech in limited public forums, we have made it perfectly clear that religion is a viewpoint from which ideas are conveyed. Analyzed under this framework, Hastings' refusal to register CLS pursuant to its non-discrimination policy, plainly false. As previously noted, when Hastings refused to register CLS, it claimed that the CLS bylaws impermissibly discriminated on the basis of religion and sexual orientation. As interpreted by Hastings and applied to CLS, both of these grounds constitute viewpoint discrimination. As Hastings stated in its answer, the discrimination policy permitted political, social, and cultural student organizations to select officers and members who are dedicated to a particular set of ideals or beliefs, but the policy singled out one category of expressive associations for disfavored treatment. Groups formed to express a religious message. Only religious groups were required to admit students who did not share their views. All environmentalist group was not required to admit students who rejected global warming. An animal rights group was not obligated to accept students who supported the use of animals to test cosmetics, but CLS was required to admit avowed atheists. This was patent viewpoint discrimination, but the very terms of the non-discrimination policy, the university ... selected for disfavored treatment those student groups with religious viewpoints. It is no wonder that the court makes no attempt to defend the constitutionality of the non-discrimination policy. The court is wrong in holding that the accept all comers policy is viewpoint neutral. The court proclaims that it would be hard to imagine a more viewpoint neutral policy, but I would not be so quick to jump to this conclusion. Even if it is assumed that the policy is viewpoint neutral on its face, there is strong evidence in the record that the policy was announced as a pretext. Here, CLS has made a strong showing that Hastings' sudden adoption and selective application of its accept all comers policy was a pretext for the law school's unlawful denial of CLS's registration application upon the non-discrimination policy. Here, Hastings claimed that it has had an accept all comers policy since 1990, but it has not produced a single written document memorializing that policy. One final aspect of the court's decision warrants comment. In response to the argument that the accept all comers policy would permit a small and unpopular group to be taken over by students who wish to silence its message, the court states that the policy would permit a registered group to impose membership requirements designed to ensure that students join because of their commitment to a group's vitality, not its demise. With this concession, the court tacitly recognizes that Hastings does not really have an accept all comers policy. It has an accept all dissident comers policy. And the line between members who merely seek to change a group's message, who apparently must be admitted, and those who seek to a group's demise, who may be kept out, is hopelessly vague. Justice Kennedy takes a similar mistaken tack. He contends that CLS would have a substantial case on the merits if it were shown that the all-comers policy have a substantial case on the merits if it were shown that all-comers policy was used to infiltrate the group or challenge its leadership in order to stifle its views. But he does not explain on what ground such a claim would succeed. The court holds that the accept all comers policy is viewpoint neutral and reasonable in light of the purposes of the RSO Forum. How could those characteristics be altered by a change in the membership of one of the forum's registered groups? No explanation is apparent. In the end, the court refuses to acknowledge the consequences of its holding. A true accept all comers policy permits small and popular groups to be taken over by students who wish to change the views of the group expresses. Rules requiring that members attend meetings, pay dues, and behave politely would not eliminate this threat. The possibility of such takeovers, however, is by no means the most important effect of the court's holding. There are religious groups that cannot in good conscience agree in their bylaws that they will admit persons who do not share their faith, and for these groups the consequence of an accept all comers policy is marginalization. This is where the court's decision leads. I do not think it is an exaggeration to say that today's decision is a serious setback for freedom of expression in this country. Our First Amendment reflects a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. Even if the United States is the only nation that shares this commitment to the same extent, I would not change our law to conform to the international norm. I fear that the court's decision marks a turn in that direction. Even those who find CLS's views objectionable should be concerned about the way the group has been treated. By Hastings, the Court of Appeals, and now this court, I can only hope that this decision will turn out to be an aberration.